Abusuan any come out channel so ha AG politics abadi. Na amai sem ya jemre na yedi bi epsom owa ha. Ani dium ene ahombrasim. Onia mesrok se yembo ingura eye political housing ejadema enye asempoto akra. Na lawyer and the Appiah Kubi. Shanosmam say even though watwen ho afri eye Wontumi ni case na ho nemom ye other cases a ono na handle ezim bank ene tanonumri ni nyina ono ne die nim as a lead counselor na Shanosmam say Wontumi e man a proud notice say sen case say ejelina onyina mu na wo appeal enye de emfama no we say na ene okopie mu ewo eye afedo kansi dumadi so ewo eye key point so obusa ne say na eside na Wontumi eka kire wo say senkesi bia jelina ginemu ma no na wo kire say ansa na judge ne betrase na o making pronouncement no na omu edikan anya proud notice no Wontumi edikan anya proud notice no because ohwe eye people omu chichire eye nsem no egu so eye proceedings no omu chichire egu so eno enye official document from court eye A4 sheet na court nankasa ewo omu ankasa sheet omu ediye omu proceedings na ohwe mu proceedings no anko court registrar no po ho wan first stamp anye dey amoso indicate say verdict we say every registrar no ho ana every court we see ho enti ohun say pronouncement omu eye ne de na ekame akoye say omu edikan ahyehye ho dada impo uhwemu lawyer na wodi asem nanim eye lawyer Appiah samre no na lawyer Appiah ni ho enso hwe verdict ni ma enam se no medical prepaint no na ni din enne ehihyehi onua owura no ajemre abra obo nchiremu mesho say emomram ehwe ne ko ne de ba aha AGH project ab
all is well?
Very well.
Okay. Have you visited your former client or yes. Is he still your client? No, he's still your client on some cases.
In other cases, yes.
Yes.
You see,
have you visited him in one?
I have visited him. He's doing well.
When?
Yesterday.
He's doing well.
He's doing well. He's
I see.
doing well.
Did he tell you anything at all?
No, that was a conversation between client and the lawyer. We're not supposed to discuss.
No, I'm asking you this because you see, the day he was imprisoned, I spoke to you, and you said on the morning of the day he went to prison, he called you, and he said you should do what?
Indeed, I told you, and I still stand by that, and that is the fact also. He told me that he had prior information that he will be convicted, and therefore gave me instructions first after the conviction.
I see.
And this is a fact.
He had prior information that he was going to be convicted on Monday.
And again, I am going to show you why probably he had that prior information. This is a copy of the judgment. Look at it. Judgment didn't go to even the registry of the court. So there is nothing to show that there is. This is on a regular A4 sheet. The courts have their own sheets that they use in publishing judgments. So there is no indication of the stamp of the registry. You go down there at the end of it, and it says that counsel, and in this particular case, defense, Appiah for the first and third accused persons. Appiah was not in court on the day. So it would have been that Mr. Appiah could be holding the brief of Samuel Appiah.
But you were not in court on that day.
No. I'm saying
you're just taking an example.
Somebody else,
but even before we get in
somebody else held the brief on the day.
Right.
So ordinarily,
the person's name
will come, and then you refer to the lead counsel or the senior whose brief the person was holding. Now, so this is a publication that came even before the judgment.
Did you ask that's Chairman Wontumi
No.
further on Monday why he suspected that he was going to be convicted on that day, even before he went to court in the morning.
And I'm saying that he probably had a copy of this before the judgment.
He had a copy of the
judgment before it was even read. And I'm justifying that with these observations. But the most important thing I want to say today is that people who have not had opportunity of reading the proceedings,
the judgment.
People who have not had opportunity of even reading the address and going about relying on only the judgment and making some pronouncements.
We'll get into
These
that.
people don't have the necessary experience.
Some of them are actually blaming you
these
for not doing a good job.
Let me finish.
Yes.
These are observations of the judge, not observations of the total proceedings. And in any case, the matters that were cross-examined on that form part of the records may not have been picked by the judge. It doesn't mean we didn't cross-examine on those.
Okay, we'll get to that. I think you're referencing page 28 and 29 of this ruling.
Yes.
Well, I'll get into that. that. But why would Wontumi call you on the morning that, look, if I'm jailed, start appeal processes? You were not his lawyer at the time.
Yes, but appeal is a different process altogether. When the judgment is given, a client has the opportunity to change for the purpose of the appeal. So it doesn't follow that you do the case up to judgment and you continue as of right to be the lawyer for the appeal. No, he can change at any point in time. Probably at that time, he thought that if it happened that way, he would prefer that I probably be part. And indeed, from my discussions with him yesterday, he still wants me to be part of the appeal because
I've washed your hands off the case.
Oh, yeah, but you can always come back.
What did you see?
Because the appeal is a different process altogether
Right.
from the instant case.
What did you see? The reason why you took the decision that in the dying days of the case, say, I don't want to have anything to do
I
with
gave
you
my
again.
reasons at the time that because of the environment that we have created as prosecution and defense and even the court, it was not conducive for us to pursue justice under the circumstances. So sometimes personality crashes and things like that may bring situation in the courtroom even not conducive enough for us to be able to collectively seek justice. And indeed, don't forget that the object of the judge or the court itself is to seek justice. But if personality clashes are preventing all of us working together to seek justice, then it means that we need to recreate an environment that will give us that opportunity. And I thought that at that time, opting out to bring in a new person who would continue. And let me also put it on record, any new person coming had every opportunity, if you found the evidence inadequate, to recall witnesses. Indeed, he had even opportunity to recall even prosecution witnesses, defense witnesses, and even call new or fresh witnesses. So the inadequacy of the evidence cannot fly because if you had opportunity to do that and you do, the presumption is that you found the prevailing evidence as adequate, for which you rely on
Appiah
to do
could
your
have done
address.
that. He didn't do that.
Of course.
Okay.
Yes.
So they came in at a time where the expectation was that they must, the case was determined to a certain point, and dates for judgment was fixed. So they were boxing.
That is not the case.
Because they pleaded to do a few things and they were not granted the occasion to do it.
Anytime you come in and you are recognized, and don't forget, when the new lawyer came in, time was given to him to even observe. And
judgment date had already
been given.
Yes, but it was changed. But it was changed.
It was changed from
Yes, because
even application. I'm coming. Even application for interpretation was quashed, and because they wanted to.
That is another matter.
Yeah, I'm just saying that there was no leg room for them to maneuver.
There was a room.
But let's get to the
given to him because at the point that he came in and announced himself in the case.
Okay.
The matters were all before him. And he said that I need to even study the brief, which was his legitimate right.
Yeah.
And it was all given. And having studied the brief, then you will come in with your prayers. I need to recall Mr. A or Mr. B or even call a fresh witness. At that point, if the application had gone that I need to recall Mr. A, it was something that the court would have determined and allowed for Mr. A to be recalled. And don't forget that Article 19(1) requires that he be given adequate time preparation to be able to prosecute his defense. So he had every opportunity to recall or call any person to come to the box and give evidence.
I see.
Again, even if he wanted to even recall or call new fresh evidence, the application would have gone. There was no such application. Okay. If he needed any information beyond that which was provided to him, he could also have called for it. And again, I'm sure that he applied for record of proceedings, which normally it is a thing that you do at first instance so that you have opportunity to
yes, how far the case has traveled.
And but you won't rely on the information I give you. You have to apply for official information from the court, the record of proceedings. So there was every opportunity to do anything if he found. But granted that that application didn't come, there's a presumption that he found the records to be adequate. So as for him, he must hold his peace. The person who has not had the opportunity...
Appiah must hold his peace. Yes. Hold on, I'll come to you, please.
Wait a minute.
No, I'll come to you. No, yes,
so listen to me and follow. The person who would not have had the opportunity of reading the whole brief, particularly reading the record of proceedings and reading the address upon which the judgment would also consider, and comes out to say that you didn't do A, B, C, D, thinking that it is only the judge who has the preserve of lifting parts of the evidence in his or her judgment.
Okay.
Without listening to
you are going into the details, but I wanted to find out from you. See, the narrative that has been put out about Chairman Wontumi's imprisonment is that he's a political prisoner. You handled this part of this particular trial. Do you agree with that?
I agree that the evidence on record cannot support the verdict.
Is he a political prisoner?
Well, I'm saying, I mean, I didn't see any politics in the records, but what I'm saying is that the judgment cannot be supported by the evidence. That one is, and that is in any case, that is how I will interpret the situation. But again, subject to three wise men who will also look at what we are all saying. But I'll be firm in my conviction that the evidence here in this records cannot support the conviction. If I have the opportunity, I will even tell you about the particulars of offense and even read the particulars of offense and see that it is even wrong. They said, for the first one, particulars of offense, you Wontumi, that you in the year 2024 in Samraboy, nothing happened between Wontumi and anybody in Samraboy. To start with, nothing happened between. Wontumi had not gone to Samraboy at any point in time, and there is nothing like that.
He hadn't gone to Samraboy. He had a concession in Samraboy.
Yes, he had. No, he didn't have concession to begin with. Did he have anything to give Wontumi as a person? And in the case of Wontumi and Akunta Mines, it was Akunta Mines that had the concession, not Wontumi.
Who owns Akunta Mines?
No. That's a different question.
No, that's the question.
No, that's a different question.
The trial judge lifted that corporate
a company, or I am a shareholder or my director of a company, doesn't make the company me. And therefore, if the company has something, it is not for me. So for you to even say that I gave something to Mr. B is flawed because I didn't have it. And the basic principle in law is that nemo dat code non habet. You can't give what you don't have.
Well, but the
so when you accuse him, no.
To lift that corporate veil,
we are doing
and pierce it and attack the owner.
No, that is in civil law. Please.
That's what
criminal liability is strict. It's strict liability. You understand? When you are my brother and you go to misbehave and they are charging you, You cannot say that because I am related to you, I am also equally guilty. You see, we'll come to all that in the appeal. But what I'm saying is that primarily, Wontumi didn't have any concession to give. So if you charge him for having given the concession, if Appiah Mining had been charged alone, then the defense would be different. But Wontumi as a person, did he have it?
What arrangement did he have with Henry Okum?
No. Did he have it? The answer is yes or no. If he didn't have it, what did he give?
No, that's a question I'm asking you.
You see,
what did he give to Henry Okum?
And did he give anything in the records, in the evidence? He did not give anything because he didn't have anything to give. So I'm just saying that.
Okay. So who instructed Henry Okum to go on the land to do reclamation, or who gave that arrangement between the two of them?
If I don't have anything, can I instruct you to go and do something?
So then, how did Henry Okum land?
No.
I'm asking, how did Henry Okum appear on that concession?
So it is a concession in the name of Contempt Mining Limited. So it is only Contempt Mining Limited who can give. So granted that there is allegation that Wontumi may have engaged Henry Okum.
It's not an allegation.
No.
It's a fact.
No. Let's see. If Henry Okum Wontumi engage Henry Okum, in what capacity would he engage Henry Okum? If it's in respect of concession belonging to a next person, Contempt Mining. So if he even acted for and on behalf of Contempt Mining, where is Wontumi in this transaction? That's a person. And don't forget that the law is that the cooperative body is different from Wontumi, a director or a shareholder. So why charge Wontumi? And if you think that Wontumi was a rightful person,
is answered in the judgment. That's why I'm wondering why. Because you have the full judgment.
So those who are
and that question is answered in the judgment.
So
reason why the
that is why you are referring to the lifting of the bail.
Question, yes, that question is answered in the full judgment that you have. That reason why Wontumi was charged, and not Contempt Mining.
So alternatively, listen,
I think.
So alternatively, if it is Wontumi who would have given the concession to him, where is also Contempt Mining? Was there anything left for Contempt Mining to have also done? So charging Wontumi and Contempt Mining, and the same case was a multiple charge and identifying multiple persons for a commission of one offense. So what I'm saying is that if you are charging Wontumi based on your civil principle of lifting the bail, where was Contempt Mining? And if you are charging Contempt Mining for having the concession and giving it out, where was Wontumi? So to begin with, I'm saying that why the two of them are charged for committing the same offense, not that they have, one of them would have facilitated or joined, or you see, I'm talking about the offense of assignment. So how did the two people all assigned?
Wait, your client at the time you were his lawyer.
And all these things are in the address.
Hold on. During cross-examination, he admitted to that arrangement with Henry Okum, correct?
Who admitted?
Chairman Wontumi.
I didn't cross-examine Chairman Wontumi.
No, I'm specifically reading from the judgment.
I cross-examined.
I'm not talking about you cross-examining. I'm saying your client. I didn't say you.
And in law and in the criminal practice, the client, he is not supposed to prove any innocence.
But your client admitted to that. I know. But you were in court.
So my client, when he was under cross-examination, he says that I engaged him.
Exactly.
He engaged me and allowed him to reclaim the land.
Absolutely.
Reclaim the land. Listen. Reclaim the land, plant coconut tree, and we will share the proceeds of the coconut tree as we harvest.
So he should plant coconut trees.
Well, you know that the judge didn't mention at all what Wontumi had said as the arrangement between him and Henry Okum.
But Henry Okum on page 28.
The judge rather accepted the version of Henry Okum, who says that yes, I approached him. He agreed for me to go and reclaim the land and plant coconut tree and also mine.
Yes.
And Chairman Wontumi comes to say that, and there's no corroboration. Nobody else came to say that, yes, I was there when they did
right
this.
and the other is not.
And so both of them are on the roof. Now we have Henry Okum who has given a caution statement denying that I didn't do anything.
We in some other team course or channel so, Mammy and also Jim Bed, as an so why in the Dumbia Dominia. You say a share.